I'm sorry about that, Judge Satterfield. She's getting right on.
Okay. I gotta go to a million different places to figure this stuff out. So JJS is 15 and is the daughter, right?
Amy is the daughter and she's 15.
Okay. What?
Emmy is 15, JJ is 18.
18.
Okay.
I did have a typo in my DRA, Your Honor, so I do apologize if that's what's confusing you.
Okay. ELS. And then did JJ graduate from high school in May?
No.
So he's 18, but he's still in high school.
He's not in school, Your Honor.
Okay. Did the parents agree for him to quit school?
Yes, Your Honor.
Last year's his first year out. So
He's been out for over a year. Or about a year.
Okay. All right. Well, I don't think there's going to be a duty to support him when he turns 18. Do you, Miss Newell?
We would like to leave that option open. I don't know that we're asking for child support right now, but we would like to leave that open.
Okay. And which one has the seizures?
That's the son who's 18.
Okay. All right. Now the petitioner appears with Ms. Newell, her attorney. The respondent appears with his attorney, Ms. Schooler. Ms. Schmitz filed for divorce, seeking the marital residence, primary residential custody with no parenting time other than what the children's schedule allowed, and well, the parties could, I guess, reasonably agree to in the divorce. Also, spousal support. The respondent has filed a motion to modify, of course, answered the petition for divorce, but filed a motion to modify. So maybe Ms. Schooler, since you filed an amended motion to modify, I couldn't figure out what you were changing. So what was it that why did you file the amended motion?
I believe it's just to change the court date. We initially had this set and then we had moved it.
Okay.
And I could be mistaken, but I'm pretty sure that was the only change.
Okay, good. All right. So at any rate, they are requesting that the court provide for a shared custody arrangement, that the spousal support be reduced to an 18% differential from a 28%, and that child support be decreased to mom to $150 with father paying all the direct expenses. And then, of course, there have been tons of allegations against each other, for sure. Fairly serious allegations. So the only thing that I will state to you is that I can't remember if it's Topeka's or Harvey County's maintenance formula, but generally speaking, I think it's 20%. And probably that's what I would do on a temporary basis. And whatever I do on a temporary basis never suggests what I'm going to do for a final hearing. I don't know how long the parties have been married since 2005, so an 11-year marriage almost, or essentially.
21.
Oh, since 2005. Yes, I'm sorry, 21. All right. Well, that's a significant marriage for spousal support. So it just kind of depends on the property division and the assets and the need and et cetera, et cetera. But as I tell most of the attorneys, at least from Wichita, spousal support usually for me is not a problem during the temporary period of separation, adjustment, and transition. So I'm certain that I would give spousal support, and I'm suggesting that you split the difference and do 20%. The child, I think, is going to be a lot hairier because there appears to be allegations of alienation and so I think the 50-50 proposition is and the spousal or the child support, I'm sorry, situation for the one child is probably the big issue. And I don't know that we're going to get through it in 45 minutes, but I'm happy to let you proffer your evidence if you wish, and if I think I need to take any particular testimony, I will. Keep in mind that I've read your pleadings. So, Ms. Schooler, it's your motion. Obviously, you've advised your clients that when a divorce gets filed, it freezes the assets. And if you incur any charge cards or debts, they're probably going to be assessed to you after the point of separation. So any dissipation of assets should have ceased. So again, I think our primary issue right now is with the daughter and parenting time and child support. And Ms. Schooler, it's your motion, so I'll have you go first.
Thank you, Your Honor. So as you noted, we are asking for a reduction in spousal support. Is currently at 28%. We were asking for 18% reduction. Just based off of our domestic relations affidavit, you can see even with our proposed numbers, my client is still negative. So the numbers as they are right now are putting him into a hole where he's going to continue to incur debt. I'm not going to go too far into all the allegations. I understand you just kind of touched base on them, but one of the most important ones that would be a violation is she has blocked my client's number, or did at one point, which is a major issue in this case. But in regards to Emmy and JJ, which I understand JJ is not necessarily subject to these court orders, we will discuss him a little bit. So, Your Honor, if you noticed in our Exhibit G, on May 8th, Emmy is talking to her dad over text message, talking about how she's going to go to the soccer game. She seemed really excited, asked for his permission. I believe they exchanged an I love you. And then the next day on May 9th, when this divorce case was not only filed, but my client was served, the child immediately needs space all of a sudden and is hardly replying to my client. And at that point, from then on, my client has not had a single minute of parenting time with Emmy. He has gone to her softball games. He has gone to her choir concert. She will not speak to him. She will not even speak to her grandma. So this has gone incredibly sideways already. The child did write a letter to my client saying it was all her idea, but we know from JJ, who is now an adult, that Mrs. Schmitz has absolutely degraded my client in front of him and Emmy, in front of her family, and JJ had to tell her to stop. So my client even asked just to have a hug from his daughter on Father's Day, and she would not even speak to him. So those orders and parenting time cannot stay how they are because they will not be followed if there is any kind of loophole. That's why we are asking for 50-50, a week on, week off. She alleges abuse, Your Honor. My client is, a bit traditional in his ways. He's authoritative, he's ex-military. He does not like to, be told no. He expects his children to do great and work hard in life. And one of the main issues that the daughter even acknowledges is her room. And if you look at our exhibits that we attached.
Okay, hang on just a minute. This exhibit G, where does it come from?
Your Honor, these are text messages pulled from my client's phone account.
Well, they're not in the format that I usually see text.
Yes, Your Honor, he downloaded them from the provider directly. They are not the typical screenshots.
Okay. Does your client have an objection to the court ordering Our Family Wizard or App Close or something of that nature for communication moving forward?
Ms. Schmitz does not object.
Okay.
We do not either, Your Honor.
Okay. Which app do you two prefer? I've not navigated through them, but my understanding is even communications with the children can occur through there to make sure that they're appropriate. And I'm trying to remember, Amy, do you remember which app our last case that was where, I don't know, is there one that you two prefer? I think there are like 3 or 4 of them out there.
The two I typically use are App Close and Our Family Wizard. I believe Our Family Wizard is the superior app as it will hold transcripts if needed, if the parties pay for it. It has a lot of extra options.
Okay, then that's what I want to use then. So I am going to order that. Let me ask you this question because of time constraints here. Would your client be willing, if he gets designated time with his daughter like every other weekend and one night a week, to then go to domestic conciliation and or mediation to talk about what a shared arrangement might look like?
Yes, Your Honor, and we are actually going to be requesting today that him and Emmy go to therapy together. I don't know if that was going to be another one of your inquiries, but that was just, we are requesting that as well because we understand life is changing for everyone.
Okay. Now, she goes to Circle, is that right?
Correct.
And mom lives in Andover, right? Is that what I wrote down? Where did I write down?
She's in El Dorado.
No.
Oh,
Where is she?
okay, I'm sorry.
She said no, I got nervous.
I wrote pet issues. I wrote their employers, but for some reason that's.
So I think I know where you're going. Miss Newell wrote that the children shall remain in El Dorado schools.
Okay.
The parties live in El Dorado, but the daughter attends Circle.
Okay. So they both live in the same town now.
My client has temporarily relocated to Wichita. He's residing with his mom until essentially this hearing, so he can kind of budget where he can find somewhere to live.
Okay. Well, where would he be exercising parenting time with his daughter?
At his mother's residence until he finds his own place.
Okay. And how far away is that? Because she's not able to drive, so what would be the transportation?
2817 North Edgemore, which is like between Woodlawn and Oliver on 29th Street.
So it's northeast Wichita, Your Honor, so they would be able to hop on K96 or 254 and it wouldn't be too long. Would you be
Okay.
providing the transportation?
Yeah, I have to pick her up.
He would be fine with picking her up.
Okay. So, Ms. Newell, have you talked with your client about I'm not a big fan of, first of all, just loose sort of visitation where the parties agree, unless they get along so well that it's never a question, which doesn't happen very often. And I'm not a big fan of whatever works for the kids, because then that puts them in charge of a situation or deciding things that really aren't a child's prerogative, frankly. So have you talked to your client about what parenting time might look like, and what she can live with?
I have, Your Honor. All three of these people, Miss Schmitz, JJ, and their daughter Emmy, have been living with an abuser for years. The text that I sent you, your office, I don't know if you've had a chance to look at them, show what it is like living with him. One of the texts was from the therapist who acknowledged that the father is a trigger for the son for his seizures, and acknowledged that he yells at them. The mom told me that the weekend that dad moved out, and we had him served and he moved out immediately on that Friday, that was the first weekend that the son had no seizures, because father was not in the home, and they had a great weekend. Mother tells me that father has been coming to Emmy's softball games. She plays left field. He sits out there and he cusses at the teammates and yells at her throughout the game. She doesn't want to have anything to do with him based on his behavior. Now, we can blame this on the mom, but right now, mom is the only constant that these two children have who is not abusing them. I don't believe that they can go to domestic conciliation, because I don't believe that there is any hope that they will come to an agreement. You might think about appointing a guardian ad litem who can talk to Emmy and get the full story in a way that is, and talk to mom and talk to dad. But you can see from the texts, you can see from the text that dad has sent to daughter that he is abusive. He sends texts like, "If I died tomorrow, you'd be okay living like this." And she says, "This is what I've been talking about with the manipulation." That's an awful thing to say to your daughter. You have your own problems to figure out before you even try and fix me in the way I see things. This is a 15-year-old. And then he goes on to tell her, "I know your mother has filled your head with lies about me. I'm sorry I didn't do a better job when you were younger. Do you believe I did your mother wrong? Just remember, there are two sides to every story." These are texts that are not appropriate for him to be sending to their daughter.
Is she in counseling? Did mom
No,
put her in counseling?
no, she is not in counseling.
Is mom in counseling?
I believe she's getting ready to go back.
Okay. Well,
To start.
That's always my first premise. If there's significant issues like this, then everybody better be in counseling, and I better be hearing from a counselor.
And we can do that too. If you want to, I know money's an issue in this case, and guardian ad litems are not cheap. If you would like to start with some therapeutic visitation between dad and the daughter, and you ordered that, the daughter would do it. But to be honest with you, at this point, Your Honor, you're taking dad's word, you're taking my client's word. But
No.
no.
What I'm taking is a parent's right to co-parent and have parenting time with their kids. First of all, that's a basic, fundamental premise. And also where there's no documentation prior to this separation of abuse or allegations of abuse, no police reports, no therapy reports, no any of that, then you have to understand that it becomes suspicious when that develops at the moment of separation. And additionally, if I have a mom or a child and a parent that gets along, and then all of a sudden there's no contact or communication at all, not in person, not on the phone, not anything, that is problematic. So the other thing is that domestic conciliation isn't just about, oh, they're going to agree or not agree. That's mediation. Domestic conciliation gives me recommendations if I have parents who can't come up with a plan that they think's best for their child or children. So
will the domestic conciliator also talk to the daughter?
they will, a child that age, yes.
Okay.
They may not divulge the conversation to the parents,
right?
But they will have one for sure. So, but if money is an issue, and no, whether it's a guardian ad litem or a domestic conciliator, it's not going to be free. But rarely do I have a situation where a parent's saying, I'm not even going to give you a Saturday. I'm not even going to give you a Saturday to Sunday. I mean, especially when she gets a temporary order and just says, as the daughter wishes, as agreed to between the parties. I mean, I didn't make a finding of sole custody. It's just surprising to me that we've gone to this extreme. But I'm going to look at both of your exhibits here for a minute. Anybody have an idea of who could do father-daughter counseling?
We'd have to find someone in network, Your Honor, but I think we could coordinate that, me and Miss Newell. I don't think that'd be too difficult.
I'm not familiar with that area, but I'm sure we could find someone.
That Micah Gross with parenting
Parents First Place or something like that. Parents Place.
Yeah. Does a really good job with co-parent counseling, but I don't think that these folks are in that category. I did have one case where, it was messy, but the dad got the daughter to go to father-daughter counseling, and it did wonders for them. But I cannot remember who the therapist was that kind of held themselves out as a father-daughter therapist. So, Amy, do you know which case I'm talking about?
Off the top of my head, I don't, Judge.
Okay. I don't know if we've got something in the files. Hang on just a minute. Let me, I don't think anybody quite advertises, hey, I'm a daddy-daughter therapist. Hang on just. daughter there. Okay.
The worst would.
Is it the daughter that has the farm permit?
Yes, Your Honor.
So mom is much more permissive than dad.
That's our
Well-
position, Your Honor.
On that allegation in the motion, Your Honor, my client says that that's been taken care of and that will not happen again.
Okay,
She understood that that should not have happened and that will not happen again.
okay, yeah, because it's not good when parents separate. One parent's extremely permissive and the other one's not, because teenagers always prefer
And
permissive parent
correct. And right.
or more permissive parent, I should say.
And I don't believe that the issues in this case stemming from one parent is more permissive than the other. I think it's a lot more complex than that, but I understand that you're looking through the exhibits.
Okay. Oh my. Now that is a messy room. Wowza. Okay.
That is not new, Your Honor. My client tells me that those pictures were taken when father was still living in the house.
Yeah.
I can also tell the court that the parties have agreed to put the house on the market.
Okay.
So that will obviously be cleaned up in the house. And I have an agreed order that I need to get over to Ms. Schooler. And I'll get that done in the next day or two. I'm just far behind.
Okay.
But I think the parties have agreed to, and she can confirm that with me, but I believe neither one of them on their own can afford the house. So I believe they've agreed to put it on the market.
Okay. Do they have any equity in it?
Yes, Your Honor.
I can't say for sure because I haven't looked at what it's going to go on the market for, and I haven't looked at what they owe on it for this hearing.
Okay.
It's not substantial, but there is obviously a little bit.
Okay.
Okay.
I don't know that, but
I always hate that for the kids and the party's sake. They both have to get new homes and totally recreate their lives. But it sounds like they both are realistic enough to know they can't afford it on their own, and they both are going to need some cash. So that's what you have to do. Yeah, I'm not even going to look at their assets or liabilities or anything right now. I'm just mostly concerned with the child, the daughter, what we're going to do to give him his access, but protect the parties until we get a third party involved in this or a trial. So I think so the answer is, the schooler, is they're not going to agree to every other weekend and one night a week. So, what I'm inclined to do is every other Saturday at grandma's and then get the two of them in counseling, and then he can go to all of our activities, and then they can communicate on our family wizard. Until then, that's kind of, I think, the best decision, and do the alimony at 20% differential. And the child support's gonna, I mean, he's just not gonna get any reduced time credit at this point on a temporary basis, and get their house on the market, and kind of see where we end up. Now the question is, do we go with the GAL, or do they go to domestic conciliation at like, oh, hang on. So this is one that I have tomorrow where we got a report and the kids weren't interviewed. And this is from Collaborative Success Inc. So that's really your choice. Do you want an attorney or a GAL? Or do you want to go with, my preference would be Collaborative Success, domestic conciliation, so that I get some recommendations, and it does follow our local court rule. Whatever they, I don't know they'll agree, and I don't want them in the same room. I don't think that's a good idea until people are in therapy.
Are you
So
speaking to me, Your Honor?
So I'm not sure if you just want to start with daddy-daughter counseling Saturday. Not going to give him a night during the week, because I'm not giving him overnight, but he can go to all of her games, and he can start communicating with her on Our Family Wizard until the attorneys can talk, or
Your Honor, the
I
only
don't know
issue,
what your suggestion would be. I've got to do something right now. And probably the only thing I'm very comfortable with, no matter what, I've got to look at, is a Saturday at grandma's. And I don't know that I want to do every Saturday for the child's sake.
I think she plays summer softball, like competitive softball. And I can't say that she plays every weekend, but I think she has a pretty heavy summer softball schedule. So I don't know how that fits into Saturdays.
because that's the point I was going to make, is my client won't really get parenting time on Saturday because she's going to be playing softball all day. And if he's already been spending time at the ball fields watching her, and that's fine, but he's not going to get any parenting time or a chance to see her. So we would ask if you add at least Sundays, which she's probably playing if they make the championship, or Friday nights or evenings.
Yeah, I would, if you order him to at least have 2 hours with her, Your Honor, which I know is not a lot, but probably given what you've read might be enough. My client will follow it, and we will figure out every other weekend on a Friday, Saturday, or Sunday around her softball schedule what would work. I would tell mom that we have to work through that.
Okay. Well, we're going to start with 4 hours every week. That's not softball. So they can pick an afternoon, they can pick an evening, they can pick a Saturday, they can pick a Friday night, they could pick a Sunday. Dad gets 4 hours every week.
Okay.
And And actually, until he gets moved to El Dorado, he probably needs more like 5, given a half hour to get there and a half hour to get back. If she's going to be at grandma's house, but I want a minimum of 4 to 5 hours. Every week, our family wizard, 20% on alimony. Child support is what child support is, and I'm going to order dad into daddy-daughter counseling, which please keep in mind, if this pans out as a very exaggerated situation, it doesn't play well for the other parent. And I know the attorneys tell people when you're making very strong allegations against the other party and things, when the dust settles, it doesn't pan out, the judge remembers and can see in the record where these very serious allegations have been made that aren't being supported within the record. So please keep that in mind in the future in terms of, not exaggerating circumstances or events or anything else to try to push your position or your narrative. Because at the end of the day, it doesn't usually work out very well. So I'm gonna wait to see what you guys decide on guardian ad litem and or guardian ad litem or domestic conciliation. What you can agree to and what you think's best for the parties. But if mom gets an individual counseling and dad gets into individual counseling, and then he does daddy-daughter counseling with the daughter, then I think we're off to a good start in seeing what direction things are going to evolve to. And once the attorneys start working on the financials, because that's very stressful too.
Mm-hmm.
So once you get the house up for sale and kind of sort through the finances, I know Miss Cooler, your client, wants to see his financial picture. It's probably not going to be very pretty in the interim. But hopefully, maybe some of their assets can be sold and or leveraged for them to get reestablished. All right, what else do you need from me?
Your Honor, at the end of my motion, there were a couple miscellaneous things. If my client's, his father passed and he inherited a couple things, Ms. Schmitz has acknowledged they were inherited. One of the 2002 Chevy Silverado, mirror dresser and firearms. He'd like that property. Just because this is very contentious, we'd like to kind of get some things separated now. We did ask for 2 of the dogs. She would remain having 3 of the pets. I want to word this correctly. We are okay with Diesel staying with Mrs. Schmitz so long as my client has the first right of refusal, because Diesel has kind of become JJ's therapy dog. So if JJ goes off to college or moves out and doesn't want to take Diesel, my client would like to have Diesel back. But he doesn't want to take Diesel away from JJ. So I don't know how we can work.
That's
You want to
the
preserve
other
that
thing.
issue?
If you're going to claim that dad has caused seizures with JJ, I am going to have something saying that from a doctor.
Okay. I've requested that.
Okay. So there's going to have to be a medical doctor that will vouch and say these seizures are a direct result to terror and trauma. Or we need to just abort that whole line of argument And really, JJ's going to be 18. I know it sounds like he has some real limitations, but I'm not going to be able to do a whole lot with him on anything because he's going to be 18. I'll let you reserve arguing for things, but there's really no legal duty to support or provide contact or anything that's not by agreement if the child's not still in high school and is 18 that I'm aware of. So what about these items? Can we, Ms. Newell, your client's willing to turn these over to him, knowing that they're items that were our family heirlooms?
Your Honor, my client's response to those, let me go to the motion.
And just so Ms. Newell can respond all in one, Your Honor, just to make this go a little faster, we are also asking for the items from his taxidermy class and the euro mounts that they found walking his property. I just didn't want us to come back to property twice.
Okay.
My client's response is that Mr. Schmidt still owns the 2002 Chevy and has stated that the daughter can drive it until she can find another vehicle that he originally was going to assist with, but now he refuses since she's not speaking to him. He is welcome to the mirror dresser and all, but not the original firearms at this time. I'm not saying we won't agree to it later, but I'm saying at this time, the firearms stay where they are.
Okay, well, where firearms be placed in a neutral third party's hands?
They are in a gun safe, is my understanding. But I don't know if it's a large gun safe or a small gun safe.
Well, what about the, well, I mean, the vehicle is his, and the daughter is only supposed to drive to and from school and to and from work. So she can't even drive to her practices. And so, I mean, I'm going to have to give him the car. If his car, he inherited it and he doesn't like the liability of her driving it when mom allows it and he's not there, that's his call. And then of course the taxidermy and his tools and
the taxidermy was not inherited. I think all that was inherited according to this motion was the 2002 Chevy Silverado mirror dresser, which is fine with my client. He can have that.
well, what are we talking about? Taxidermy equipment to do taxidermy? Or are we talking about stuff that he's hunted, that he's had taxidermied, or he taxidermied it himself?
That's cool. Do the job.
They're his projects from his taxidermy schooling, so he did create them.
Which occurred during the marriage.
Right.
So those
they're not stuff she hunted that she wants that she should keep.
they may have a value, Your Honor. I don't know yet.
You can put a value on them, but he can get his taxidermied item. I just want to make sure that he is he in the business of doing taxidermy for people where he makes money on the side?
Not at this time, Your Honor.
Okay. So what taxidermied items are we talking about?
So there's a list of everything that did GI Bill, and there's 4 live mounts that I actually shot. That's some else to do.
So some of them he did actually shoot on. There's a mountain lion, 4 live mounts that were done with the GI Bill, 2 live mounts. I mean, these were all done during his schooling. There's a turkey, a coyote, a pheasant, European mounts, antlers, a bass.
paid for.
I mean, they're still going to be divided in marriage, but
Okay.
she's already violated the temporary orders multiple times at his expense, changing car insurance. She sold her car. I'm very concerned leaving any of his prized possessions that he cares about in her care.
To be honest, that's an exaggeration. But for purposes of today, I will advise my client to take pictures or videos of everything,
Yes.
and they can go with Mr. Schmitz. But he is not to dispose of them either, Your Honor, please.
They're not going nowhere.
Okay, so, you guys are gonna find a mutual time in the next 2 weeks for him to pick up these family heirlooms and taxidermy stuff?
Yes, we will
Now,
work that out.
I don't know what to do about animals. That's kind of my Achilles heel kind of thing, because the courts, I guess, have made it clear that they are property, not children. So you don't get visits with them and somebody doesn't get custody. They are property that's awarded as part of the overall settlement. So usually what I do is I figure out who purchased the dog, what circumstances, who paid for it, what circumstances was it bought under? Did one person hunt? Was it intended to be a hunting dog? Does it go with one particular child? Who is the animal most attached to? Who pays for the food, takes them to the vet? I mean, those are the things I have to look at when I can't get people to decide. And most of the time they split up if they have multiple animals. But rarely do I have a trial where I ultimately decide where pets go.
Your Honor, we're in agreement to Amos. Is that still the case, Miss Newell?
My notes are that Mr. Schmitz is to take Amos and Felix by June 19th. Otherwise, Amos goes to Beauties and Beasts.
Well, I don't want that to happen.
What?
Unless he's, sometimes people move to apartments and they can't have pets for a while. They move to some kind of temporary residential housing or something. But if he wants the animal, I don't want the alternative to be that it goes to a.
Your Honor, she requested possession of these animals, so for her to say she's not going to get rid of them if my client can't take them immediately is incredibly insane. My client we agreed that he would take Amos, but my client needs time to get into a place where he can have them. He will make sure there's a place that takes the animals.
Okay.
But we're only requesting Amos at this time.
Okay.
These will be reserved because JJ has become very fond of him.
Okay.
And so on.
All right.
And I apologize that I don't know right at this moment. Is Amos and Felix dogs or cats?
Amos is a dog, Felix is a cat.
Okay,
What is
so
Diesel?
He's not my priority.
so it's the cat taking the cat that is an issue, Your Honor.
And just at the moment, I mean, he can
Okay.
take the cat to the barn, but I don't want to agree to that. And you guys think it's coming to his house. So I think we can come to an agreement on Felix. I just can't say at this exact moment.
We will work on that.
Okay.
We want what's best for the animals as well.
Okay, good. Like I said, fortunately, most of the attorneys at the end of the day figure out the animal situation. So, all right, you're going to work on pets.
Yes.
So, what else do you need from me other than suggesting to you a daddy-daughter therapist?
Probably nothing. It sounds like Miss Schooler and I ought to have a phone conversation tomorrow and try and work out the rest of this stuff. I don't, and I will talk with her about the options in Butler County for domestic conciliation and guardian ad litem, and maybe we can hash out which would be better for these two.
Okay. And I mentioned to you that collaborative is good at interviewing kids.
Yeah.
And then hang on, I'm gonna try to find you the therapist's name.
Okay.
Hey Sarah, while Judge is
Yeah.
away, you want to try to schedule our phone call?
Sure.
I have an 11 and then anytime after 3:30.
How about 3:30 then?
You want to do 3:30?
3:30, yeah. I can either do in the morning, before your court, or I can do at the end of the day. Whatever works for you. If you prefer earlier in the morning, we can do that too. But if if you have an 11, if that's a hearing and you need to prepare, we can do it in the afternoon.
I can do, I do not have to prepare for my 11. We can do 11.
We can do 11. I thought you had an 11, or you're open at 11.
I'm open at 11.
Oh, okay. Well, let's talk at 11 then.
Okay. Perfect.
Okay.
Sarah, the only two things left I need to talk about are the children's saving accounts funds and the tax return being not split equally. Has your client provided any of that money to you?
Provided me any money?
Well, because I ultimately asked for it to be placed into the trust account. That's the only reason why I'm asking.
No. I do not have any money from her. I know that was requested. Let me get with my client further on the children's bank account. I know what she wrote me, but I'm probably going to email her and ask her for proof of what she wrote me, just so I can forward that to you.
Okay.
And I will discuss with her the bank account, the tax return. So she got 4,000 and your client got the other 3127. Is that my understanding?
Yes.
Okay, I'll talk to her about that and see what her response is. I'm sorry I don't have a better response today.
Well, then we can talk about that tomorrow.
Okay. I've been having some issues with the clerk's office on the KPC sheet.
Yeah, I don't know. They called my office last week.
The update that I got from my assistant, and this didn't make any sense to me today. I can share it with you. The clerk says she has a call into the KPC for something. Said she is needing some information about the case. I asked her to call me when it was submitted. That was an email I received from my assistant. I haven't heard. That was at 8:31 this morning. And I've been on Zoom hearings since a little before 3:30. So if I got other emails from her on this, I haven't seen them. I haven't looked.
Because they called my office Friday asking for their social security numbers. We did that.
Yeah.
But I haven't heard back, so I don't know. I know he paid it and he showed it's been cash, so I don't know what else the issues are, I guess. They should have, or how they would still have issues if they've already received the money and cashed it out. That's odd.
She on Thursday, my other assistant, on Thursday at 4:19 p.m., I got an email from my assistant Natasha All. I called Michelle back on this issue, Michelle being in the clerk's office. She needed the full dates of birth and socials on all 4 family members. And she says she says I was able to provide her with the information she needed to update the KPC sheet and submit it. And then all my staff were out on Friday at some kind of CALA seminar. The person that does these at the court is no longer there. So other people were working on it, trying to get it done. And my other assistant said I was out of the office on Friday, so we'll reach again to check. And then I got another email at 8:31. She said she had a call into the KPC for something, she being the clerk. So that was the last update I had at 8:30 this morning. So I don't know what the problem is.
Yeah, no kidding.
I know. But this isn't the only case where I'm trying to get the KPC sheet, done.
I've never experienced this.
Yeah, that's why I was like, hey, did it,
Okay, so I'm just not finding it. I found the case that it was in. I'm not finding the therapist's name. So let me get you a couple names.
okay.
So, Your Honor, if you could tell us opposing counsel, we could probably just say, hey, we were told you know of a really good counselor, or we could give them a
Is
call.
that it? I think that's it. Okay. Hang on.
Um, Family therapy.
I'm
And that
looking
was-
at Erica Lewis.
Yeah. That's the name that shows up between petitioner and the child in an order.
Where is Erica Lou? I don't know that name. I guess I
Mental
can
health
Google her.
therapist.
November 21.
Wichita State University graduate, clinical mental
There's an
health.
Erica Lewis, licensed professional counselor in Derby.
Okay, probably it.
Erica Lewis, master's, home, family
showing-
therapy, Amy Meek's office.
That's the one I'm showing is Amy Meeks professional.
Amy Meek's office. Okay.
All right. Will you try? How about you try there?
Okay.
And it
Your
was
Honor, the-
specifically referred to as daddy-daughter counseling.
Okay.
And that particular father had a very strong personality, and of course, that child was very troubled. Not like this child. So, but still, that's the dynamic. So that's probably the model that we want to use.
Okay.
All right, and then let me get a review date so we can see where we are. Do you think there's going to be a lot of discovery on the financial and all of that, or do they all have good records of PQ?
I think there might be a little bit, Your Honor.
So June, July. You want to touch base August the 7th?
Sure.
I'm available.
All right. Let me see if I'm not seeing. Or I could do July 28th at 10.
I would
Yeah.
prefer the 28th if possible.
Okay.
Oh, and I was going to say the 7th, get me out of the month of July would be best.
Okay. Okay. That might run in, that day might be problematic. I actually have a domestic day on August the 11th, but that's when school starts. And I hate to go that far out with just 4 hours a week unless you guys see some possibility of increased, like one overnight or something.
I think it's too early to tell on that right now, Your Honor, but I will say that Miss Schooler is easy to reach. So I don't foresee that if I need to get in touch with her, that I won't be able to get in touch with her.
Okay. How about if we do August the 11th at 3 by Zoom for an hour? And if something comes up where you feel like you've got some evidence to work with, either through therapists, physicians. You've got some Our Family Wizard stuff. You've got some therapy sessions that were successful, or the parents just both agree that there are changes because there's no more softball, and they, the attorneys, you can agree on an increased time, or if you can't, then you contact me and I'll see if I can work you in a few, for probably not more than 2 hours, but 2 hours earlier than the 11th if I need to.
Okay, but so we're scheduled for Tuesday, August 11th at 3:00 for now.
Yes, for a status.
For 1 hour Zoom status.
Yes.
And give you an update on therapy, Our
Right.
Family Wizards, any session notes, if the parents are able to come to any agreements, so on and so forth.
Perfect.
Okay.
And then, Ms. Schooler, I'm going to have you
Journalize your own.
on the spousal support, if there is any on the child support, and the visitation stuff. And then on the 11th of August at the status conference, you can announce to me at that point whether you want to set it for a pretrial conference and an actual trial date. So I can give those to you on the 11th if that's the direction that we're headed. And of course, any agreed orders between the two of you, I will sign. So if you have an agreed order to put the house on the market, then I'll just submit it by agreement. I'll sign it.
Okay.
All right. Thank you for your time. We are adjourned.
Thank you.
A daughter walked into court with a shocking claim. She was entitled to part of a deceased man's estate, but the family had one response. We've never even heard of her. The courtroom immediately shifted from a routine inheritance hearing to a battle over identity. The woman insisted she was the biological daughter of the deceased and asked to be recognized as a legal heir. The other heirs didn't completely reject her claim. Instead, they demanded proof. No birth certificate, no family records, no witnesses who could settle the dispute. So the judge turned to the one piece of evidence that couldn't be argued with, a court-ordered DNA test. Both sides agreed the results would determine whether she truly belonged in the family, and whether she had the right to inherit. The judge approved the testing and set a final hearing. Now, one DNA report could rewrite an entire family's future, because in probate court, a single scientific result can change an inheritance forever.